Hello, everyone. I'm here today to present a short webinar on evicting a tenant in California. My name is Steve Blake. I'm a licensed California attorney. I've been practicing real estate law for approximately 20 years and handle a lot of commercial landlord-tenant disputes. So in today's presentation, generally, I'm going to talk about evicting a commercial tenant, what steps go in connection with that, starting with the lease agreement, the notice to quit, the UD lawsuit, serving the summons and complaint, tenant response, the court hearing or UD trial, the post-trial activities, including a writ of possession, the enforcement of the writ, recovery of unpaid rent, and ensuring compliance with tenants' rights. So the eviction process in California is primarily driven by the California Code, and it involves, removing a tenant from a piece of real estate when they're unwilling to voluntarily leave. And in California, you're not allowed to perform self-help, which typically means, if I am a landlord and I have a tenant that isn't paying rent, I can't just go over to the property, throw out their stuff into the street, and change the locks to the premises. That's considered self-help, and it's illegal in California. You have to follow the eviction process, which, as I mentioned earlier, is set forth in the California Code. When you do have a landlord-tenant dispute for a commercial property and you represent the landlord, the first thing that I recommend is to actually review the lease agreement. And with commercial properties, 99.9% of the time, you're going to have a written lease somewhere. Very rarely is there no written lease, but assuming there is a written lease, you're going to want to take a look at that, understand what the rights and obligations are with respect to the landlord and tenant and the specific breach at issue, because there can be different types of breaches. There can be a non-payment of rent. There can be a breach that involves failing to maintain the property or some damages at the property or something else. So you're going to want to look at those provisions in the lease and see what it says about those types of defaults. And then look at what the default provisions say in terms of how do you notify the tenant that you believe that they're in default? Do they have a right to cure that default? How many days do they have to cure it? How do you need to give notice? Is there a particular, mailing address or other means of giving notice to the tenant? So after you've reviewed the lease and the tenant is still in default, and for my example, just they haven't paid rent, then the next step would be to serve them with a notice to pay or quit. And in the notice to pay or quit, it's going to inform the tenant of what the default is. And then if the default is, for example, unpaid rent, how long they have to cure that default. So typically under the statute, it's 3 days, but sometimes in a commercial lease, you're going to want to review it and make sure that the parties haven't negotiated more time, because sometimes a commercial lease will have a 5-day notice period or a 10-day notice period. So whatever time you're going to give them to cure, you want to make sure it's consistent with what was in the lease agreement. After the notice to cure, pay or quit is sent out and served on the tenant, assuming that they don't cure within the time period, then the next step for the landlord to regain possession of the property is to file the unlawful detainer lawsuit. And in an unlawful detainer lawsuit, you're going to file it in the county where the property is located. Most counties in California have a specific eviction department in the courtroom, which would be handling the case once it's filed. And a note here on the slide is that in California, the unlawful detainer lawsuit is limited to possession of the property and unpaid rent as of the date that the landlord regains possession. So basically, you can get back rent that's owed up until the tenant's out. But one thing you're not allowed to get in an unlawful detainer is future rent owed under the lease. So I put in here in the slide, if you still have 3 years left on the lease and you evict the tenant, you're not going to be able to get that 3 years of future rent in the unlawful detainer proceeding. You're going to have to file a separate civil case for those future damages. And then when preparing the unlawful detainer lawsuit, you want to make sure that you include as defendants that anybody who's in possession of the property. So if you're aware of any subtenants or anything like that, you typically want to include them on the unlawful detainer so that when you do get a judgment, it'll apply to those parties as well. After the lawsuit is filed, and in California, typically, you'll file the lawsuit electronically, and then you're gonna end up, waiting a year or two to get it back from the court with your summons signed and a case number assigned to the case. And once you have that, you have to serve it on the tenant. And it's similar to a regular civil lawsuit in terms of service. You have to attempt personal service on the tenant. And usually this isn't a problem because you know where the tenant is located, but sometimes it can be, and you might have to do something else like substitute service or posting and mailing it, which you need to get an order from the court in order to do that. Assuming that service was completed, in an unlawful detainer case, the tenant has 5 days to file a response to the complaint. And typically, the tenant will file an answer to the complaint, which just consists of a general denial and some affirmative defenses. But they are allowed to file a demur if they, have grounds to do so. So there are other things you can do to respond to the complaint other than just filing an answer. In the event that the tenant does not respond at all to the unlawful detainer complaint, then you can request a default and default judgment, which in my experience happens quite frequently in unlawful detainer cases. If you have a tenant that's not paying rent and you file the eviction case, serve it on them, a lot of times they either don't have the funds necessary to contest the lawsuit, and so they just allow you to take their default, or they vacate after you filed the lawsuit. This next slide is relevant to an unlawful detainer trial. And this would happen if the tenant files an answer in the eviction case. Then the next step for the landlord is to file what's called a request to set the case for trial. And since unlawful detainer cases are considered expedited or summary proceedings in California, the court typically sets the trial date within 20 days of receiving the request to set case for trial. So it comes up pretty quick. You're going to want to file that right away. As soon as the tenant files an answer, I typically try to file the request to set case for trial the very next day. UD trials are somewhat similar to a regular civil case trial, but in a lot of ways very different. Typically, a UD trial takes place in an hour or less of time, and you're in front of a court commissioner or a superior court judge. You're not in front of a jury. The trials are a little bit more informal than a regular civil trial. The plaintiff, who would be the landlord, it's their burden of proof to show that the tenant, had a contract, they breached that contract, that notice was given to them, that they failed to cure under that notice, and that the landlord, because of that, is entitled to terminate the lease and regain possession of the property. And then also prove that you've suffered this amount of damages in unpaid rent, which would differ in every case. Sometimes it's a couple months, sometimes it could be a year. So at trial, tenants defense, they're allowed to present their case and be heard by the court. Sometimes they may have a defense in that the amount stated in the notice was not correct and it should be something different. and therefore, the notice itself is invalid and the UD case can't go forward. That can happen, and there's a way to prevent this in commercial evictions, is that the code in California allows a commercial landlord to state in the notice that the amount is a reasonable estimate of what is owed. So if that's in the notice, it allows a little bit of wiggle room for the landlord. If the notice amount is off by a bit, it doesn't make the notice defective. So that's one potential defense, is that the notice is defective. Another potential defense is that the notice was served incorrectly. Like I said, there could be provisions in the lease that mention how notices need to be served under the lease. And then also the statute requires a certain method of service as well, for notices to pay or quit, which is typically personal service on the tenant, or posting it and mailing it to the property if nobody is at the property of that's able to accept personal service. So there's not a lot of defenses a tenant has to a typical non-payment of rent eviction. They may argue that they're withholding rent because there's some issue with the property that the landlord is responsible for, that the landlord's not fixing. That could come up. So if it's a heavily contested UD and you anticipate there's going to be a trial coming up, you're allowed to do discovery in an eviction case, just like a normal case, except the timeframes are shortened in terms of response times. So if there's some hot button issues that you think will be litigated, it's wise to serve some discovery before the trial to get the defendant under oath as to what their responses are to those issues. And then, like a normal civil case, you can take a deposition if you want of the other side. So that comes up from time to time. Most of the time, in my experience, discovery in eviction cases is pretty limited, just because of the shortened time frame of getting the case to trial, and parties sometimes are concerned that if they engage in discovery, it could delay things and not get the case to trial as quickly as the landlord wants. The next thing I wanted to talk about briefly is, after assuming the case goes to trial or the landlord gets a default judgment, once the landlord has that judgment for possession, the next step is for the landlord to apply to the court for a writ of possession. And this is just a standard judicial counsel form that has some boxes that need to be checked and a little bit of information that needs to be filled in. But you fill this out, you give it to the court, and the court signs that document. And this is an important document because this is what allows the sheriff's office to potentially lock the tenant out of the property in the event they don't vacate. So you get the writ of possession, and what happens with that is that it gets forwarded to the sheriff's office, who oversees the lockout. And the sheriff's office will, once they have the writ of possession signed by the court, they will prepare a notice to vacate on the tenant, and they'll serve it on the tenant. And once that notice is served, it tells the tenant that they have 5 days to vacate the premises, or else the sheriff can come back on the 6th day and forcibly remove them from the premises and change the locks. And I've gone through this process many, many times in various counties throughout the state of California. This part of the eviction process, there's oftentimes some delays. The sheriff's departments that serve the notices have this in their queue, but unfortunately, a lot of times they don't get the notice and serve it the very next days. Sometimes it can take a few weeks for the sheriff to serve the notice. And then after they serve the notice, it's important to keep in contact with the landlord and the sheriff's office to monitor the property to see if the tenants vacate. Because if the tenants do vacate after they get that notice, then the sheriff doesn't want to have to come back out to the property to lock them out, because obviously there's nobody there. So if the tenant vacates, we'll have the landlord confirm that they've left. And then if that's the case, change the locks And then we'll notify the sheriff's office that they don't need to complete the lockout because the tenant's already vacated. However, if there's any question that whether or not the tenant's vacated, like if they're gone, but it looks like maybe they left some stuff there, or there's a car in the driveway, or if there's any question that the tenants has not vacated, I always recommend to have the sheriff complete the lockout, because that's the final stage in the process. And once that's done, you have a legal right to possession of the property, or the landlord has a legal right, and the eviction's complete. You don't want to call off the sheriff and then the next day, somebody's back at the property that, claims they have a right to possession. As I mentioned earlier, the recovery of unpaid rent is available for back rent owed in the eviction case. However, future rent is not available. If you do get that judgment for rent, it's like any other judgment in California. You can collect on it under the law pursuant to what the code allows. So, you'd have to levy on assets of that tenant in order to get paid. They may have an ongoing business, they may have bank accounts. If it's under an individual's name, they may have wages that they're receiving from somewhere else. So there's a lot of options to collect on the rent. You just have to understand what the tenant's assets are. And then lastly, it's important when you are proceeding with the eviction of a commercial tenant that you fully understand all the legal protections that they're entitled to as a tenant under California law, because any mistake in the process can give the tenant grounds to defend the lawsuit at trial. So you want to make sure that all your T's are crossed and I's are dotted, which is why I mentioned at the beginning that you want to start with reviewing the lease and make sure that you follow the lease exactly as to what it requires for a default of the tenant in providing notice. Again, there's some pitfalls, and I've seen cases that have gone all the way to trial, and then the tenant's able to defend the case because there's a defect in the notice or how the notice was served. In my experience, when I have a client that's a commercial tenant and there's a tenant that's defaulted in rent or some other default, I prefer to serve the notice to pay or quit myself through our office, because we've done it so many times. We understand the nuances regarding service and notice. I've had a lot of clients that serve the notice themselves, and it turns out that it was served incorrectly, and we have to start over and serve a new notice. So just be mindful that there's a lot of laws in California that provide rights for the tenants that may not be addressed in the lease. So thank you very much for this presentation and watching. I hope to give a pretty big side picture of the eviction process. There's a lot of details that I obviously didn't go over, but I hope you understand the general process for doing an eviction of a commercial tenant in California. And thank you very much. And please visit our website, or feel free to email me if you have any questions about evicting a commercial tenant in California. Thank you very much.